action for joint is a plaintiff, sixth plaintiff, was filed under certificate and it had been served. I plead to place the following few matters on record. One, the intended sixth plaintiff, in seeking to be enjoined in the current proceedings, had in mind saving judicial time, for the reason that the courses of action it has, the complaints it has, are similar, some identical, to the complaints raised in this proceedings. And therefore, filing separate proceedings would not only have clustered the court diary, but would have compromised on judicial time. It's much neater for all the parties with similar causes of action arising from the same transaction to be heard in the same proceedings. So that should be considered by this noble court.
You have served your accusation?
Yes, it has been served.
Yes.
We even have affidavits of service. The second issue I want to mention very briefly is that West Kenya Sugar Company Limited was the highest bidder at 36 billion Kenya shillings, compared to Sarrai Group, which bid at under 6 billion shillings, 5.8, a difference of 30.2 billion shillings, which, if we are enjoined, we will be seeking to get an explanation on from the receiver manager and from Kenya Commercial Bank. So I plead that because we would want to be heard on the application coming up for hearing today, that was coming up for hearing today, on the plaint itself, because West Kenya Sugar Company Limited wishes to have the opportunity to be heard going forward in these proceedings, our application for joinder be considered at this early stage, because that will inform the way forward. I thank you.
My lady, if I could address you on behalf of the eighth defendant respondent. My lady, I want to put it on record that when we appeared before you on the 14th of January this year, the respondents had not filed their responses, except for the first and second defendant respondents who had filed a notice of preliminary objection. And on the 14th, this matter was coming for direction and I emphasize directions. The court then proceeded to hear and determine the application dated 11th January 2020 by the plaintiffs without the benefit of the respondents or defendants filing responses. And orders were made in those circumstances, despite the fact that there were notices relating to the jurisdiction of the court. Now, my lady, I'm saying this because I am pleading with the court not be attracted to consider any other application in the same way, particularly for joinder, when we have had no time from the time of service to respond to those applications. And with respect to the remarks made by Senior Counsel, Mr. Muite, the issues about whether the highest bidders or not, we should be given an opportunity to make those responses. Because it would emerge they did not qualify. But that will be getting into that application, which we don't want to. My lady, then?
Senior Counsel, you said you need time to respond to the applications for joinder.
For joinder.
How much time?
At least 3 or 4 days. Because, my lady, we are having a multiplicity of suits. Some of them which have been determined, some of them which are ongoing, and all these matters need to be placed before your lordships to determine whether West Kenya and others have a reasonable stake or a local to be had. Because in our submissions, we think some of them are just busy bodies. My lady, therefore, before you can consider any other application, I plead with the court to proceed what the court directed should happen today at 11 or thereafter, because the court explained that your list is long and you are likely to be had after 11, after the court had cleared the other matters in the court's list. So I'm pleading with the court that under the circumstances in which the orders were given on the